Today we're going to talk about defenses to evictions. As a landlord, you're going to need to know that, and as a tenant, you're going to want to know that. Now, before I get into individual defenses, which I will get into in different videos than this is sort of an introduction to those defenses. And it's going to sort of give you the skeleton of the whole body of the defenses so you can see how they all interrelate. I know everybody wants to get that one piece of information that they want that is perfectly on par with their case. They want to skip right to that. But the problem is legal analysis is a process. It's not just something where you just go right to something and bang, you find it. You have to understand how it all fits together. If you don't understand how it all fits together, that piece of information, that one argument that is perfect, that just bangs right into your head and is perfectly there for you, if you don't understand the overall process, you might not recognize it. It may slip by you. Or you may think it's a perfect thing, but because you don't understand the whole process, there's one little step that's been left out, and now you're done. So let's talk about this a little bit. First of all, we need to think about the three types of defenses that a tenant can assert to an eviction in the state of Ohio. And it is important to know that this educational video is for landlord-tenant law issues in Ohio only. Now, some of these lessons may have applications in other states. I wouldn't know because I'm not certified to practice in those other states right now. I'm only certified to practice in Ohio. Secondly, while I am a lawyer, and while this is about law stuff, I'm not your lawyer because I don't know you. I've never met you, and I don't know the facts of your case. So if you're going to treat this as legal advice, then you're going to be doing so at your peril. That said, let's talk about the three types of defenses to evictions. The first is the simplest type. That's what's called a merits defense. A merits defense is the landlord says you have an unauthorized dog in violation of the lease, and you say, I don't have a dog, I don't have any kind of pet, I have not violated the lease. The landlord says, some other landlord says, you didn't pay the rent on time. And you say, no, I did pay the rent on time, you just deposited it late. That's a merits defense. It's whether the law is not in question, it's just a question of the truth or falsity of the allegations. Okay, those are merits defenses. The second defense type would be what are called legal defenses. And legal defenses turn upon not just the facts, but about what the law says. So a legal defense, I should say, might be the interpretation of a certain clause in the lease. And if the judge were to interpret that clause one way, then what the tenant did was allowed and it wasn't a violation. But if the court were to determine it another way, then maybe what the tenant did was in fact a violation, and therefore the landlord would be allowed to go forward with the eviction. So that's the second way of defending an eviction, is through a legal argument. Everybody's agreeing what the facts are. The question is, what does the law allow? Now, the third way of doing this is what's called a procedural argument, sometimes called a technical argument. Procedural argument might be that, gee, the law states that you have to have certain mandatory wording in your in your 3-day notice to vacate, and you misspelled one of the words, or you left out one of those mandatory words. It's a legal argument. You're supposed to give the tenant 3 days to vacate before you file your forcible entry and detainer action, but you didn't. That's a legal argument. Or maybe you did, and that's a legal argument. So then there's also a species of procedural argument. They're not really arguments, but their effect, if successful, is much the same, or can be. They're like delaying arguments or delaying procedures. For instance, in Franklin County, Ohio, if the eviction is set for the first time on, say, April 5th, and the tenant and the landlord show up, and the tenant, even though he's known about this hearing for the last 2 weeks, going to be on April 5th at 9 a.m., well, he walks in and says, "Your Honor, I need time to get an attorney." Well, the rule in Franklin County is you get one continuance to get an attorney, and you don't have to defend why you didn't have an attorney already. You don't have to defend why you didn't call earlier to get an attorney. It's just you ask for it, you get it. But you're generally only going to get one continuance. So that would be a procedural device that has nothing to do with the law or the requirements of the law, but just sort of the way the court works. These things can delay an eviction, but they won't be able to eventually stop an eviction. Of course, the tenant may not be out there to actually stop the eviction. The tenant may just need an extra week before his new place opens up, and so he asks for the continuance, he gets the extra week, and that's his goal. He's now got his goal, and now he's not going to fight anymore. Maybe the tenant needs an extra month, and there can be some things that you could do to try to string it out that way too. So these are the three types of evictions that you're going to see and that I'm going to address in other videos. Now, we also have to think about whether the argument that the tenant is making against the landlord is a very powerful argument or a not so powerful argument, or one that's really a reach. That's going to be hard to tell because it's going to depend upon how the judge, the hearing officer in charge of the eviction, is going to see things. And so what you don't want to get into is some sort of a gamble where, gee, the tenant does have an argument, but you're never going to know how well that judge is going to see that argument, whether he's just going to dismiss it and say, no, I'm granting the eviction, or he says, gee, that's a winning argument, I'm going to dismiss. So I'm going to get into that in a different video as well, and how you should sort of get into wheeling and dealing with a tenant and how to think about these defenses that these tenants may assert or are going to assert or don't assert. So that's the end of this video, and we'll get into the more substantive things in videos to come, which should be on the channel pretty quickly.